I am Dr. Shivani Gupta from the University Institute of Legal Studies, Punjab University, Chandigarh. Today, I am here at Jagat Guru Nanak Dev Punjab State Open University, Patiala. So today's topic shall be sexual offences in India. Let us understand the basics of as to what kind of acts constitute and by whom shall they constitute as sexual offences. So sex-related offences are universal phenomena which take place in every society. Sexual offences aptly take the form of sexual violence, which sometimes cause severe and irreparable damage to the physical and mental health of the victims. Physical injury includes an increased risk of a range of sexual and reproductive health problems. Its impact on mental health can be equally serious as that of physical injury. Sexual offences, when they assume the form of sexual violence, may lead to murders, suicides, acute depression, etc. of the victims. It entirely disturbs the social well-being of the victims because of stigmatization and the consequential loss of status in their families and the neighborhood. A wide variety of sex-related offences take place in different circumstances and social settings. In India, sex crimes against women and girls are mainly manifested in the form of rape, molestation, sexual harassment, kidnapping and abduction for sexual purposes, and trafficking of girls for sexual exploitation. Sexual molestation, sexual harassment cases have been on a continuous increase. Buying and selling girls for sexual purposes as well as procurement of minor girls for inducement in sexual trade have shown an alarming increasing trend. Sexual offences in India are addressed through various laws. Earlier, it was through the Indian Penal Code 1860. I will start from earlier it was through. Earlier, it was through the Indian Penal Code 1806 only, while presently it is covered under many laws, primarily being the Bharatiya Nyaya Sanhita 2023, which has incorporated in it the provisions of the Criminal Law Amendment Act 2013. Even laws like the Sexual Harassment of Women, Prevention, Prohibition and Redressal Act 2013, commonly known as the POSH Act, and the Prevention of Children from Sexual Offences Act 2012, commonly known as the POXO Act, also strive to lay protective laws for protection of women and children against sexual offences. Let's take a brief look at the various provisions and try to understand as to what constitutes a particular offence. So, at the very first onset, we will start with the Bharatiya Nyaya Sanhita 2023. The first provision we will talk about is Section 63, which corresponds to rape. It states that a man is said to commit rape. So, the first and the foremost thing that we need to understand here is that under BNS, rape is a gender-specific offence where it is only a man, that means a male, who can only be the offender, and the woman, that is a female, who can only be the victim. Though the law doesn't specify the age of the man or the woman, however, there are some things which have to be understood from the following text. The law on rape, which was earlier contained in Section 375 IPC, that existed before the 2013 Criminal Law Amendment, used the words, a man is said to commit rape who has sexual intercourse with a woman against her will, without her consent, and many such provisions. Thus, it was necessary for the prosecution to prove the act of sexual intercourse. However, according to medical jurisprudence, the act of sexual intercourse can only be possible if the man is able to have an erect penis. Thus, this requirement became the scapegoat for many who could prove false impotency through medical evidences. This, however, is not the case now with the application of the present law. The new law has widened up the scope of the offence of law to include a wide range of acts like penetration of penis to any extent into the vagina, mouth, urethra or anus of a woman, or make her to do so with him or any other person, or insertion to any extent, any object or a part of the body, not being the penis, into the vagina, the urethra or the anus of a woman, or makes her to do so with him or any other person, or manipulates any part of the body of the woman so as to cause penetration into the vagina, urethra, anus or any part of the body of such woman, or makes her to do so with him or any other person, or applies his mouth to the private parts of the woman under circumstances like against her will, without her consent, with her consent, but after putting her in fear of death or of hurt, with her consent, knowing that he is not her husband and that the consent given by the lady is only because she believes the man to be her lawfully wedded husband, with her consent, such that when she was in a stage of unsoundness of mind or intoxication, or with or without her consent when she is under 18 years of age, or when she is unable to communicate her consent. In the case of Independent Thought versus Union of India, the 2017 Supreme Court judgment, the court has categorically laid that an act of sexual intercourse or any other sexual act by a man with his own wife, the wife not being under 18 years of age, is not rape. Thus, our law does not recognize marital rape as an offence. The law also explicitly defines that consent shall mean an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. Further, absence of specific physical resistance shall not constitute consent. In the case of Kaini Rajan versus State of Kerala, the 2013 judgment, it was held that the presence or absence of consent can only be ascertained on a careful study of all the relevant circumstances. The present law under section 64 makes the offence even more heavily punishable when the acts constituting rape have been committed by a person of authority like the police officer, public officer, a person in fiduciary authority upon a pregnant woman, etc. These acts amount to custodial rape. Custodial rape is an aggravated form of rape. It is an assault by those who are supposed to be guardians of the women concerned that are specially entrusted for their welfare and safekeeping. In case of custodial rape, the physical power that men have over women gets intensified with the legally sanctioned authority and power. A positive change under the Sanhita is the insertion of section 69, which makes an act of sexual intercourse by employing deceitful means or by making false promise to marry a woman without any intention to fulfill the same as a punishable offence, but has specifically and categorically laid out that the same shall not amount to rape. The probable reason behind the exclusion of that act of sexual intercourse at the time was neither unconsented nor unwillingly done. Though the law is gender specific, however, it has made attempts and has intended to be gender neutral for victims and perpetrators in case of offences like gang rape, which are given under section 70, where even a woman can be prosecuted for the offence as an AD or abettor. If a woman is found to be a part of the gang and common intention to commit the offence of rape is established, she shall be prosecuted for the offence of gang rape. The next provision is outraging the modesty of a woman. Section 74 criminalizes the act of outraging the modesty of a woman. Though the word modesty has not been specifically defined anywhere in the Sanhita, however, the Honorable Supreme Court, in the case of Raju Pandurang Mahle versus State of Maharashtra, the landmark decision of the year 2004, has held that the essence of a woman's modesty is her sex. According to the Oxford English Dictionary, modesty in relation to a woman means an act decorous in manner and conduct. Further, in the case of State of Punjab versus Major Singh, the 1967 judgment, it was observed that the reaction of a woman is relevant, but its absence is not always decisive. What is important is that the assault or use of criminal force was with the intention to outrage her modesty and with the knowledge of the likelihood of doing so. Next, we will talk about sexual harassment. Sexual harassment is defined under Section 75 of the Bharatiya Nyaya Sanhita and is also made punishable, whereby acts such as physical contact and advances involving unwelcomed and explicit sexual overtures, any demand or request for sexual favors, or act of showing pornography against the will of a woman, or acts making sexually colored remarks shall all amount to sexual harassment. However, till date, the offence is gender specific as the offender can only be a male while the victim can be both men as well as women. In order to prevent incidents of sexual harassment against women at workplace specifically, the legislature gave effect to the Sexual Harassment of Women Prevention, Prohibition and Redressal Act 2013, which provides specific remedies for sexual harassment at the workplace. The whole law is the result of the landmark judgment delivered by the Honorable Supreme Court in the case of Vishakha versus State of Rajasthan, the 1997 decision. Section 76 criminalizes acts of assault or criminal force against any woman where they are intended to disrobe her or compel her to be naked, whereby, to understand, an act of pulling the dupatta of a woman with the intention to disrobe her shall be an offence punishable both under Section 74, that is for outraging the modesty of the woman, as well as under Section 76. Next, we will have Section 77, which punishes the acts of voyeurism. It is very important and necessary to understand this, especially in the present time when we are living in the age of computers and internet. It states that any act of watching or capturing the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator shall amount to voyeurism. Further, any act of dissemination of such images shall also be punishable as an act of voyeurism. In simpler terms, capturing images of women while attending calls of nature or while trying her clothes in a try room, such that either she was captured in her undergarments or that any of her private body parts were visible, shall amount to the offence of voyeurism. The law further states that dissemination of any image that was captured with the woman's consent but disseminated without her consent shall also amount to the act of voyeurism. There is another provision which is not gender specific but is intended to protect the dignity of individuals. That is Section 296 BNS, which makes punishable the performance of any obscene acts in a public place, including singing or reciting of obscene songs, words, etc. Next comes a paramount shift, that is, the removal of Section 377 IPC from the new law, that is, we can say, the decriminalization of same-sex relations. Earlier, any sort of sexual activity between individuals of the same sex was made punishable under Section 377 of the Indian Penal Code, which amounted to an act of unnatural offence constituting sodomy. The landmark and unanimous decision of the Honorable Supreme Court in the case of Navtej Singh Johar versus Union of India 2018 declared Section 377 IPC as unconstitutional. Thus, under the present law, acts of consensual sexual conduct between adults of the same sex are no more an offence. This decision also became the foundation stone towards the protection of many other rights of the LGBTQ+ community. Next, we'll talk about child sexual abuse. The Protection of Children from Sexual Offences Act 2012, popularly known as POCSO Act, is a gender-neutral legislation providing for the welfare and safety of children irrespective of their gender. As per Section 2, Clause D of the Act, a child is any person who is below 18 years of age. A victim under the Act can be a male or female child. The Act does not create any distinction between the victim or the perpetrators on the basis of their gender. There are instances when women are convicted under this Act for child sexual abuse. There are basically three broad categories of sexual offences under the POCSO Act. First is sexual assault. Any act of penetrative sexual assault or an aggravated penetrative sexual assault. So, penetrative sexual assault shall mean touching the private parts, that is, the genitals and the breasts of a child, or making the child touch the private parts of another person with sexual intent without penetration. Whereas, aggravated penetrative sexual assault means sexual assaults on a child by a police officer within the vicinity of a police station, by armed forces within the limits of their area, by a public servant, by the staff of jails, hospitals or educational institutions, etc. The second categorization is sexual harassment. It includes basically 6 kinds of cases, that is, uttering any word or sound or exhibiting any object with sexual intent to a child. Next, making a child exhibit his body so that it is seen by the offender or any other person. Next, showing any child any form of media or pornographic purposes. Next is constantly watching or stalking a child directly or online. Further, threatening to use a real or fabricated depiction of any part of the body of the child or the involvement of the child in a sexual act through electronic, film or digital. Next will be enticing a child for pornographic purposes. The third kind of offence under this particular act is using child for pornography. It includes representing the sexual organs of the child or using a child in real or simulated sexual acts, or representing a child indecently or obscenely in programs or advertisements on TV or on the internet. We cannot complete the knowledge of this topic without we talk about trafficking of women and girls for the commercial sexual purposes. Trafficking of women and children and their inclusion into the sex trade is a mushrooming form of organized crime. International trafficking is a highly organized activity involving a sophisticated international network of procurers, document forgers, escorts, corrupt officials, and so on. In India, Article 23 prohibits trafficking in human beings and all forms of forced labor. Further, the directive principles enlisted in Article 39E and K declare that state policy should be directed towards protecting childhood and youth against exploitation and material abandonment. Building upon these, the Suppression of Immoral Trafficking in Women and Girls Act was enacted in the year 1956, whose aim is to inhibit or abolish commercialized vice, namely trafficking in women and girls for the purpose of prostitution and organized means of living. Thus, to conclude, there are various reasons to sexual offences, some of them being tender age, susceptibility to alcohol and drugs, excessive poverty and unemployment, and sometimes even societal isolation. They are both relevant from the point of view of the victims as well as the criminals. The new law, as far as the enactment of the enhancement of punishments is concerned, is a positive step. However, there is still scope for a wider interpretation, especially considering cases where even men can be the victims of sexual assaults and sexual harassments. That is all from my side. Thank you.